impact assessment and data protection. Today's webinar is being hosted by the International Association for Impact Assessment, or IAIA. IAIA is the leading global network on using impact assessment to make better and more informed decisions. My name is Keisha Blaser, and I will be hosting today's webinar, but you'll really mostly be hearing from our facilitator and presenters who you will meet in just a moment. Now, before we get started, I want to talk about a few different resources you can find at our website at www.iaia.org. So first, we recently refreshed our entire website, and in part of that, we created a brand new resource library. And in the resource library, you have access to all of our past webinars on demand. So there are a couple there on the screen. You can see examples from our digital impact assessment series. There is one on exploring different ways data is enhancing IA practice, which you might be interested in if you're at today's webinar, as well as a webinar on perspectives on the use of artificial intelligence in impact assessment. So you can find all those and more in our resource library. And if there's a specific topic that you're looking for, you can search by topic, and you can also search by resource type, like webinars. In addition to our webinars on demand, I also want to highlight a few upcoming events. Namely, we have our annual conference, IAIA 26, this year happening in Quebec City at the end of May. Currently, registration is about to open, but we do also have abstract submission open right now through the 30th of October. So if you are interested in submitting an abstract, please go to our website and find out more there. We also have a variety of online training courses that are available at the end of this month as well as into November and December. There are a few different courses listed there, but I do want to highlight a brand new course we are offering on decision science for IA professionals. So if you are interested in that, again, more information can be found at our website as well as instructions for registering. I want to highlight a brand new offering that will be coming soon, hopefully within about a month. We are going to have different types of on-demand training courses on strategic environmental assessment. We'll be offering a foundational course as well as a course specifically on the solar power sector and a course designed for decision makers. Next, we also have our professional development program, which is one of our bigger training programs lasting about 12 weeks. We have training on foundations of environmental impact assessment, as well as an entire course focused on social impact assessment. Registration is currently open for the course that runs from January. And again, you can find information about the course and how to register at our website. And finally, in addition to all those training opportunities, there are also free downloadable publications like our best practice principles, our IA fast tips, and more. All of that, again, is at www.iaia.org. Now, before we get started, a few pieces of housekeeping. If you have joined us for a webinar before, it may look a little bit different, so I want to just highlight a few pieces on your control panel. First up is the chat box. If there's any important links, I may send you a chat there, or any other announcements, you can find the chat. The most important one on your control panel is the questions tab, which has the question mark in it. At the end of today's webinar, we will end with a Q&A with today's presenters. And at any point during the webinar, if you have a question, please feel free to type it into the question box there. Do not feel like you have to wait till the end, till the Q&A to put your question in. If at any point during a presentation you want to put a question in, please do so. Next up, the materials. If you'd like to follow along with today's presentation or download it for later viewing, they are available now at the handout at the materials section. In addition to that, we also have an article on data protection in impact assessment that's available for download there as well. And then finally, if you have any issue with the audio or video, you might want to check your settings in the control panel. And then finally, today's webinar is being recorded and it will be posted again in our resource library within a day or two of this live broadcast. Now, I'm about to hand it over to today's facilitator and presenter. So first up, our facilitator is Ilse Oukamp. Ilse is the Director of Equispectives Research and Consulting Services in South Africa. She conducts social, gender, and human rights impact assessments, due diligence studies, public consultation, stakeholder management processes, and designs and implements social impact management strategies. Ilse is also the Director of our Social Impact Assessment Professional Development Program and has done a great job, and we are very thankful for her leadership in that program as well. So with that, Ilse, over to you.
Thank you very much, Keisha. Welcome everyone at tonight's webinar. I'm quite excited about that. This webinar was born at the IAIA conference in Italy earlier this year, and we have wonderful presenters. First of all, we have Danie Strachan. He's a senior privacy counsel at VeraSafe, so he's a real lawyer, and he helps advises clients across sectors and jurisdictions and help them to complicate this to navigate this complex area of privacy and data protection laws. And he's also the co-host of Privacy in Practice. It's a podcast that explore real world challenges, and he also speak a lot at industry events. Then we have Ildiko Almasi Simsik. She is a seasoned environmental and social expert, working for more than 15 years in all over the place with the IFC, all the big banks. But she also is the founder of Environmental and Social ENS Solutions, where she develops AI-driven tools for practitioners and create training materials. She has done everything social, and also worked in 5 continents. And she wrote an award-winning book, What is Social Impact? And she also hosts a No-Nonsense Sustainability podcast. And her writing has appeared in Forbes, Reuters, and Fast Company. So we're in really good company tonight. And then lastly, Francesca Villani is a public health expert, and she works at the moment on just transition projects. I know Francesca has also years and years of experience, and she's concentrating on the impacts of health determinants and their effects on vulnerable groups especially. And she has conducted lots of epidemiological studies, developed baselines, and as part of integrated assessments, done lots of monitoring and evaluation processes. And of course, within the health and social field, as you all know, data protection is key, and this was being required. So I don't want to talk too much. I want to give over to our very knowledgeable speakers. And as Keisha said, if you have any questions, just pop them in the question box. We will be monitoring the questions as we go on, and then we will answer your questions. So don't be shy to ask, but also remember, don't mention people's names, and be careful of sharing sensitive information. Then without any further ado, I want to give over to Danie to start with the first part of this webinar tonight.
Everybody, good morning, good evening, good afternoon. It's a pleasure to present to you today. I think it's often a misunderstood topic that we're dealing with today, and I think a very serious topic if you think about all the data that is involved when anyone carries out an impact assessment. So we're hoping today to uncover some really useful tips and guidance for you. And I'm hoping also to do quite a lot of myth busting. So as Ilse said, I'm a lawyer, so I work full-time in data protection in all sorts of sectors and industries. So I'll be opening with the legal scene, if you can put it that way, explaining when data protection laws might apply to impact assessment, and if that's the case, what do you do? Ildiko will then take it further and unpack it on a more practical level in terms of your operations when you carry out impact assessment. And then lastly, Francesca will look at it from a health impact assessment perspective. So let's get going. So what is personal data? And I think this is a key concept to unpack in today's webinar so that we know what we're dealing with, because this is what you have to look out for. So if you're not sure what personal data is, that might complicate the process. So I'm hoping to unpack all of that for you today and make that as clear as possible. So personal data, obviously a definition that has a specific wording in various laws across the world. It could be personal data or personal information or personally identifiable information, PII, as it's known in some countries or jurisdictions. So I think it's important from the beginning to make it clear that there's no global data protection law. Every country or region has its own version. So we're trying to address the topic today on a general, neutral basis. So obviously there will be some nuances differences between some countries' laws, but let's try and keep it general so that we can figure out what the principles are and how to apply them. So if you have information about someone and it can identify them, or if that person is identifiable, it is personal data. So any information relating to someone who is already identified or who is identifiable. So in other words, if you take the information and it can be used to identify a specific person, that is personal data or personal information. And the range of data protection categories is really, really wide. So personal data can be the obvious things like names, emails, phone numbers, your usual contact details. But then more sensitive information like ethnicity or race, health and sex life, sexual orientation, job titles, employment information, income, job loss, taking it a bit further to not your typical data, but images, photos that display people's faces or their names. That's information that relates to them. It can be used to identify them. Biometric information, so that is quite unique to every person. So that's something like your fingerprint or your retina scan, unique features that can be used to identify someone. And then in many laws, it goes even further, and I think this is specifically relevant in the case of impact assessment, is people's opinions, concerns, feedback, preferences, all of this, and this is typically gathered in impact assessment. This is also people's personal information. And then also inferences in many countries' laws, that is also regarded as personal data. So if you have information about someone and you make a conclusion about them, so because you've interviewed them, they haven't said something, but based on the information that they've provided you with, you make conclusions about that person. Or if you put a couple of facts together and that leads to a conclusion, that is personal data, and it's that person's data. Something that's really important to clarify at this point, because this often leads to confusion, is the difference between confidential information and personal data. When we talk about personal data, we're talking about any information that relates to someone, regardless of whether this information is public or not. So if it is information on that you can find somewhere on the internet or in a book or in a register or government records, even though it's publicly accessible, that does not mean that it's not personal data. So whether the information is secret or confidential, or whether it's publicly known, information about someone, information relating to someone is personal data. It's their personal data, and you have to look after it and comply with the legal requirements relating to that data. So the reason behind this is because organizations can obviously gather data using all sorts of public records, compile it and make it available in a different way. And if you want to do that, you still have to comply with the legal requirements. So please bear that in mind, because it often happens that people say, well, the information is publicly accessible if I go to a government office or I log into a specific website, therefore it's not personal data and I don't have to comply with the legal requirements. That is one of the biggest myths that we need to bust in this webinar. Some other common myths that we encounter quite frequently. If we remove people's names, the data becomes anonymous. I'm afraid that is a myth, and people argue about this a lot. But the point is, and then to make it very, very simple, let's say you have a piece of paper and you have two columns on that piece of paper. In column A, you have people's names. In column B, you have information about people. Let's say it is their preferences when it comes to food. Just to keep it very simple, let's say you're doing a very basic survey. I think most people are used to those kinds of marketing surveys. So you have a column with people's names and a column with what they prefer. If you take that piece of paper and you cut it in half from top to bottom, and you have two separate pieces of paper, just because you've now separated the names from the people's information doesn't mean that it's now become anonymous. Why? Because you can always put that those two pieces of the paper together again, and then you know who likes chocolate, who likes cheese, who likes cool drink, whatever the case might be. So the point here is if you've removed names or other identifying features, but you can still identify this person subsequently, then under most countries' laws, you are still dealing with personal information because you can still re-identify the person. So in many sectors, when you conduct surveys or assessments or any kind of project, often what people do is they try to de-identify the data. But what they're actually doing is they're pseudonymizing the data. So that's a huge word. It's also difficult to make sure that I pronounce it correctly. But pseudonym is a nickname for someone, if I can call it that. So what you're doing is you're replacing someone's name maybe with a code, with a string of numbers or letters, but you still have that code. So even if the people's names have been hashed, if you can still re-identify that person, that information is still personal information. And it's very clear in many countries that the regulators have this view as well. In Europe and in other parts of the world, the test is always information is identifiable. It's still personal data or personal information if you can still re-identify the person. So it's like having the key to your house. Even if you lock the doors, if the key can still be found by someone and you can lock the door, you can still get access to the house. And it's the same when you're doing surveys. If you are coding the information, but you can still decode it, you must still treat it like it is personal information. So pseudonymization is not the same as anonymization. Anonymization means that you've totally stripped all possible metadata, anything relating to the data, so that there's absolutely no way to re-identify the relevant individuals. Second myth on the screen here, people sign consent forms so we can do anything with the data. That's also a very commonly encountered myth. There's this idea that once someone has consented, you can do what you want with that data. Under most countries, data protection or data privacy or information protection laws, that is not true. Even though you have consent to use the data, you can normally only use it for express, lawful, specific, limited purposes. So you can't then use it for any and every purpose. And we'll look at some of the principles that underlie most data protection laws across the world a little bit later on. So just because you've got a consent form signed does not mean you can then share that data with anyone just because you want to, or sell that data. Not that I'm saying that that's what people do, but this is the point. Consent does not, it's not like a blank check that allows you to do anything and everything. There are still legal obligations. You still have to look after the data. You can only use it for legal and legitimate purposes, etc. The data subject still has rights relating to their data, and legal requirements must be followed. Another myth, we're not collecting data, we're just receiving data, and therefore the law does not apply to us. Most countries' laws will apply whether you're collecting the data from someone, whether you're accessing it somehow, even if you're just consulting data, so you're looking at it to draw conclusions, to write up a report. In most countries' laws, that will be regarded as so-called processing. In other words, you're doing something with the information. So why does all of this matter? Well, in many countries, there are laws, and if you don't comply, it can lead to fines. I think that's the obvious thing that people get scared of. But you also have contracts with your corporate clients, with funders, whoever asked you to do the impact assessment. And if you don't comply with legal requirements, that could expose them, it can expose you, it can lead to contractual disputes. You could even lose your contract if something goes wrong. And then lastly, it's bad for your reputation. If something does not work out and people get harmed or they get upset and it ends up in the news, you're going to be associated with that. So another good reason to make sure you comply with data protection law. So when we look at these specific laws in Europe, they have the GDPR. It's probably one of the most well-known data protection laws around. It relates to Europe, though, but most other countries in the world now have data protection or privacy laws. Each law is unique, but they have basic principles. And these principles have come around from, let's say, the late 1970s. Actually, you can take a look at the OECD principles when it comes to privacy. And most countries have based their laws on one or another form of these principles. So I want to go through them very quickly, just so that you can bear them in mind, because these principles, if you apply them, that this will help you to comply with most countries' laws. Even though laws are unique and that they have differences, this would be the baseline. So only collect what you truly need. Data minimization. I think that's the golden principle, because less data means less risk. More data, bigger risk for you. So collect what you need. You need to have a legal basis to explain why you're collecting that information. Use it only for specific purposes. That's the purpose limitation principle. Then make sure that the data is secure. This is super important, especially if you're dealing with special information that's really sensitive about people. Make sure that people can't access it, etc., etc. We'll go into that a little bit later. Ilvika will cover that. Be transparent about your data use. So this is the openness principle, the notice principle. So make sure that your informed consent forms are informed consent forms. So make sure that people know what is happening to the data, why it's being used, where it will end up, why people will share it, etc., etc., what their rights are relating to that information. And then people must have control over their data, rights and fairness. So in many countries, laws, the people to whom the information relates, usually referred to as the data subjects, they have rights over their data, so they can access their data, so they can ask you what data you have on them, they can ask you to delete it, to rectify it, to update it, they can object against your use of that data. So those rights have to be honored. And then you have to be careful how you share data. You can't just share it with anyone and everyone. And in many countries, there are restrictions when you want to transfer information across borders. Usually you can only do those in certain circumstances. Otherwise, cross-border transfers are prohibited. So you have to be very careful when it comes to sharing personal data. To leave you with a few action items from what we normally see in projects, you need to know what personal data you're processing. So map your data. What data do you have? Map the data flows. Map what processing, that is, whatever you're doing with personal information. My rule is, you might recall the rule that you often hear is if you can't measure it, you can't manage it. When it comes to data protection, my rule is when you can't map it, you can't measure it. So if you can't manage it. So if you can't map the data that you have in your organization, how are you going to manage it? So you need to be able to map it in order to manage the data. Train your team and make sure that there's privacy awareness. Carry out security reviews. These are really basic things, but they will really help you. Manage your vendors. If you're using consultants or subcontractors, other organizations, make sure that you can trust them, that their data protection and security posture is strong, that they comply with laws, so that if you give them access to people's data, that you won't have a situation where that data might get exposed or used for illegal reasons. And then lastly, get the basic documents in place. You need a privacy notice on your website. When you get people to sign forms, make sure that those forms explain how and what data is being used. Make sure that you have agreements in place with the people that provide services to you. And then lastly, make sure that you have an IT security policy for your organization. These things are crucial. And then in some countries, you might have to register if you're processing people's data. In many countries, you also have to register a data protection officer. So look into these things, unique requirements in every country. Lastly, I just want to leave you with a resource. VeraSafe has a Privacy in Practice podcast. We talk with leaders in privacy across the world, really practical insights there. So please feel free to follow us wherever you get your podcasts and learn more about practical privacy and the human touch. Thank you very much.
Okay, thank you, Danie. This was a great introduction to the legal background and the basic concepts. And now let's have a look at what happens when we go on site visit with often our personal devices, when we're acting as a sub-consultant, when we're sub-consulting, contracting other people, when we're outsourcing household survey activities, and how to actually put these data protection principles into practice. So some of these things that I listed here are things we are not doing and we should be doing more of. That means specifying the platform where we store the information. Now, if you're working for a consultancy company or a bank, this might be provided by your employer. But if you're a smaller company or a freelance consultant, this might not be something that is like obvious to you, how to make sure that you have the online platforms and the access authorizations for that are appropriate for the level of information you need. For example, if you're a biodiversity consultant on a project, there is absolutely no need for you to access the livelihood restoration, household survey, and asset inventory. For example, if I'm subcontracted as a social specialist, there is absolutely no need for me to see the financial due diligence of the company. The next thing is that we don't often specify in the contracts is how we're going to dispose of the data after the assignment ends. I've not once seen it in any of the contracts that I've signed where I was asked at the end of the assignment as the sub-consultant to provide all the data back to my main consultancy partner and then dispose of the data on my company or personal devices. And this ties into the next aspect of retention periods. Now, for some HR and tax-related information, there are legally specified retention periods, like 6 years for HMRC, but for ENS, we don't have this retention period. And it is on a case-by-case basis, and it's something that's rather challenging to come up with, so I can't give you like a number, because we can have complaints on the project years into the implementation, and then probably that household survey or notes from a stakeholder engagement would come in handy. But again, we can start a conversation and like shift the culture of data protection and impact assessment by being mindful that retention periods do exist. And now the next thing is the personal devices and the device security measures. I think I'm not the only one who's guilty of merging industrial facility site visit pictures with my weekend away with the family. This is just the reality of working in the field. You take pictures, you try to document, and very often you use your personal devices. I've been subcontracted by organizations that required increased security measures if I wanted my company emails or access to the files through my personal devices. But in general, this is all things that we don't really talk about. So I will leave you with this slide. Next time you sign a contract with a contractor or you are subcontracted, just keep these things in mind, because the same way we deal with incident and accident reporting in health and safety, that's exactly the kind of mindset and risk mitigation approach that we should take when we're talking about data protection and information security. The other big concept for a large-scale project is outsourcing survey activities. Here again, if we don't specify who owns that data and how that data is obtained, now I know what you're thinking. We often brief them what's ethical, they should obtain consent and explain what the data is used for. But if you listen to Danie's presentation, what we're doing as standard practice currently is very far from what we should be doing if we wanted to comply with the GDPR or any other data protection law. And then there's the other way of information consumption that we're transitioning through this technological innovation. So I was alerted to cases where survey data, household survey data on development projects were sold to marketing companies who are doing market research on population segments. And this is potentially violating any protection rights, human rights of those people. But because the consent was not clearly explained and obtained, and there was no reporting on the breach, this is not something that you've heard in the news probably. And then when we're talking about the data minimization, we should review the way we collect the information and what information we collect. And I know, as a social specialist with a background in social research, I know that the more the merrier. I usually only have a couple of days on site, and I use all the information, all the observations, all the inferences, even the things they don't say, but I assume, to make up my argument, to type up my notes, and to undertake my assessment. But this is not in line with the data minimization principles under, like a GDPR or equivalent legislation. So here are some practical tips and tricks you could use. Designing the survey with the purpose. We pretty much know what's the basic information we need to collect for any sort of social impact assessment or resettlement, livelihood-related things. But it doesn't necessarily mean that all of that information needs to go into the end deliverable that is going on a public website. Often we use these data aggregation like measures where instead of an actual salary, we just provide the ranges or we group the ages, and that's a good way to actually like aggregate data. And then again, it comes back to how we physically secure that information through like encryption and like access controls at various levels. Returning to consent, I know informed and voluntary are words we routinely use in the social performance practitioner field. We're talking about informed consent and participation. We're talking about voluntary participation in survey activities. But there's the more nuanced and refined understanding of what consent means and what it means for the different types of data and the different types of data use. Because very often we want to avoid survey fatigue, so we just collapse all the surveys into one. So one person goes to one household and gathers all the information, and we say, this is for the environmental social studies of this project, and we're going to put it in the document, you will be consulted on it, etc., etc. But that one collapsed survey includes information that's basic socioeconomic household data where potentially informed consent is enough because it goes in aggregated into the social impact assessment, but it might also include livelihood, income, informal livelihood related impacts and information where we might be like dipping into the more sensitive personal data aspects where explicit consent, not just for the collection, but specifying the purpose to use that data and where it will be stored and how it will be presented and where should be obtained when we're doing these surveys. And here comes this tender tension between the very much transparency-led lender disclosures clashing with the data minimization, the non-identifiability principles, and the purpose limitation. And I know, because I've been on both sides, as a lender, you want to make sure you provide full transparency over how you're conducting your assessment to prove that you're complying with your policies, you're following your processes. But very often in this good spirit, you forget about protecting the people who are affected by your project. And that's why a more pragmatic approach would probably be having a more aggregated, redacted document for public disclosure, all the confidential information for the most affected stakeholders, just for the consultation purposes, and then perhaps some information that's only left for the actual household when you're like doing your negotiations. And the important thing is how you make that risk assessment and how you document that decision, what information goes to disclosure. Now, a very, very simple example actually comes from my data protection officer, Laura Palmariello, who was on my podcast talking about data protection practical aspects. And she mentioned the FBI test. So if you had all the resources of the world, would you be able to identify this person? And most of the cases, the answer is yes. Whether you look at the stakeholder engagement plan, the resettlement plan, you often have the plot number, you often have a pin on the map, so you know exactly where it is. You might even include a picture, not of the person, but of the house. So you see it's like mud walls and like what's the material of the roofing. You provide some description of their livelihood. So you know exactly that they have 5 camels and 2 horses. And very often, unfortunately, health information on mental health and health status gets into the documents that are publicly disclosed. And this should not happen. So before the next time you're going out on the site and you're collecting and analyzing this information, just ask yourself some of these questions so you have a more informed decision on what to include in public information. This data anonymization and the non-identifiability criteria, Danie explained it very well. And I think the example of, you know, saying it's plot 72 and farmer 5, but this is the exact location on the map and this is a picture of their house, it does not mean this non-identifiability criteria. It wouldn't pass the FBI test, basically. And there's often hidden aspects like the metadata on your phone. You wouldn't think anybody would care, but we are harvesting information and data from the internet, and we're using it to train AI models and build other AI models. So indeed, the exact coordinates from a house, a location of a bird nest, or any informal logging could be taken from your photograph, and that means that the location, the ownership of that property or that land could be identified just based on a simple photograph. If you're using, and everybody's using like technology providers for data storage, AI, there are some basic questions and basic things you should do before you share your data with them. And one very crucial aspect for us is the data residency, because unlike other businesses where it might be more localized, so the data stays within the country, we carry our data with us everywhere where we work globally. And unlike the incident reporting for health and safety, we do not have incident reporting and response for data breaches and anything that has to do with information security. This is a little something to make you think. This is me. So I was a sub-consultant 12 years ago, and I still have the information on my laptop. Why? Because it wasn't in my contract, nobody cared, nobody asked for it. Now, of course, it's a lucky situation because I have a whole technology company, the most amazing data protection officer, so I can dispose of it and have the digital trail of data deletion that I could provide if anyone needs it. But some of you might not be in this lucky position. So next time you're contracted or you're contracting others, like think about where will that data travel, where will that data be stored, and what happens after the engagement is over. And I challenge you this week, or well, it's Thursday next week, think about some practical aspects where you can start a discussion and review the way, the practices that you're implementing on your daily work. It might not be an easy conversation because we have to shift the thinking, we have to change the culture of data protection and impact assessment. But as we're having this webinar and opening the discussion, I think it is time for everyone to start thinking about what is it that I can do or my company or organization can do. And I will leave you with some resources. The No Nonsense Sustainability podcast, I have 2 episodes coming up, one with Laura, our data protection officer, and one with actually Danie, where we go more in depth in the legal lens, what data protection for ENS means. In October, we're launching our training center at ENS Solutions with a specific data protection for ENS practitioners online self-led training course, and we will have all these templates available through there. And now I will hand it over to Francesca, who will talk more about data protection in health impact assessments.
Francesca, you may still be muted if you want to turn your microphone on.
Can you see my slides?
Yes, we could see them just fine.
So
Full screen.
personal health information. So I will focus very much on the health, personal health information. These are a specific, special category of personal information, and are normally all the information that are collected and handled to manage patient care. So these are individual information, but are also information that the health system and other authority use to protect public interest. So there is an individual dimension and a public dimension. We've heard about ethical reasons, legal compliance, and risk, but there is also a question of trust. We know, and we have seen it, that unless there is trust in the institutions and in the organization that collect this information and how these are used, it's going to be very difficult to get further results. And if you think about one example that we have all experienced during the COVID-19 pandemic, there was personal information that became used by the authority. Think about your test negative results or your vaccination results. This is personal health information, but could be used by authorities also for different type of reasons. And increasingly, the number of health information that are made and are collected are extremely high. So it's important to consider when you think about the data you collect, not only the how to do it and what are the regulations, but also very much the why you do it. From a health perspective, the time where we start to look at data is very much when we prepare the health baseline. The health baseline is critical to understanding both the population and health well-being status, but also to inform mitigation strategies and then for tracking impacts. At the baseline level, we collect both secondary data and primary data. Danie was referencing to, data sets and how much, collecting information for one purpose might be very specific. So although you use data that you have not collected yourself, you still need to think about what are the potential challenging risks from a data privacy protection. You might not know what was the consent used for collecting this data, or anonymation might not be adequate. And then there is, absolutely was mentioned before, the cross-border data. So although our secondary data, you still need to be careful. But when you do fieldwork and you do impact assessment, your main concern from a health perspective is very much on primary data risk. And we'll go through each one of them specifically. So Ildiko was talking about informed consent, and that's one important component. But there is another aspect that from a health perspective is very important, and is the ethical approval. So when I did a lot of health research, epidemiological study, is absolutely normal practice when we do this type of studies to develop a research protocol where we provide a lot of information on the reasons why we do certain things, how we do it, how we handle data, how we handle informed consent. What is normal practice or best practice in health research is that this protocol is submitted to some institutional review board or ethics committee, and we get an approval. The idea is that not only we have tried to adopt the best practice, but there are institutions that are supporting and approving our methods. I've never done a health research collecting primary health information without getting an ethical approval from some of these committee. And it's important to recognize that these committees are existing in any country, so there is no excuse for not doing it. If you do work with any research, it might not be the national ethical board, it can be the one of your university partner. We talked about informed consent before. I think that one aspect that is very important is also to consider that it's not enough to get a document signed, yes, or to get informed consent. The fact is that the participant can withdraw their consent at any point in time for any reason, and not necessarily they want to withdraw from the study. They might object to some component of it. I had encountered a situation where some of the participants didn't want to respond to part of the questionnaire because they thought it was inappropriate for them. Or I've seen studies where the participants, either for themselves or for their children, didn't want to be part of some type of a diagnostic test, especially if there was blood involved. Or they didn't want to be receiving, for example, treatment if this was against their belief or their religion. So the point is that informed consent is not a one-off. It's not that when it has been obtained is forever. It's something that is constantly need to be checked and monitored when you are doing your work. Another aspect that we need to consider, again, from a health perspective, is that additional safeguard might be required for various vulnerable groups. And I think it's important to consider that vulnerable groups, although we have normally the concept of who are the vulnerable groups and we have standard checklists, they are extremely context-based. So HIV positive people are not necessarily a vulnerable groups everywhere, but in areas where there is very high stigma, they might be a very vulnerable group. And it's not important only to consider if they, if we collect information from them, is that this is anonymized. It's also how do we consult them. For example, when we were doing a survey in Ghana at the time in a very rural area, the stigma was extremely high. So the health officer told us that we could have not conducted focus group discussion with them in the same location where the other focus group were conducted, because this could have led to the identification of the people, even though we might have managed to anonymize the result afterward. So we had to set up an alternative location and alternative method of consultation. So the setting and the groups need to be part of your consideration when you do your field work. And there are very many different groups. Again, it's not, you need to think about what these issues might be. The same concept apply not only to the individual, but also to the community level, especially when you have maybe small communities in certain areas. You might want to have, you might have anonymized data, but if some of the geographical group either because the group is very small or because a specific characteristic, the individual per se will not be recognized, but the whole group become labeled as, for example, unhealthy or sick. This has a lot of implication and put a lot of risk. So again, consider not only the privacy of the individual, but also what does it mean for the collectivity or the communities for which you collect this type of information. A specific example of specific type of group is indigenous people. So, of course, indigenous people have, we need to follow the United Declaration on the Rights of Indigenous People. But we also need to consider that in a lot of this group, there is a lot of existing trauma that has been due not only from the experience which they live, but also by the type of health research or health abuse that they might have suffered. So they are extremely sensitive about doing research in their areas. They consider private, their health information very much their property, and any type of work that is done in areas with indigenous people need to be very clear in which kind of information we are going to collect, and that they are the final owner of this type of information. I put reference here to 2 chapters of the upcoming handbook on health impact assessment that go very much into the details of what are the requirements. And it's important to consider that in areas where there are a lot of indigenous people, there are specific legislation. This is the example from Canada, but Australia and New Zealand have the same type of rule, and you can find the reference here. Very briefly, some final consideration. I think we've been talking about minimization, and it is true, but the reality is that when we do impact assessment, we collect a lot of different information, and different group and different experts, different teams might collect different type of information, and then we try to link them together. From a health perspective, this is very clear because we look at environmental determinants of health and we look at social determinants of health. So we work with data sets that have been collected by others. So when the risk is not individually in each data set, when we create linkages between all this type of information, then the problem might arise. So it's not only the protection of the data of the individual or of the community. We need to consider also, when we put all this information together, what can be the risk. We do it for a lot of issues, although for example, we detect noise at the household level, then we look at who are the vulnerable people inside, and this might come up, with disclosing identity, even though at the health data collection status, this was not the case. So I think, just concluding, we need to consider that a robust approach to data privacy and protection must be embedded from the outset, and all the different teams, as well as the stakeholders, need to be consulted. I was mentioning an example before. When we did the data collection in a remote area of Papua New Guinea, and there were 8 villages, one of the concerns was, for example, what if one of the village come up with much worse data than the other? How this will affect the relationship among all the groups? So we needed to involve all of them. So not only the experts need to be involved, but also the stakeholders and the communities from which you are going to collect this data. I have included here all the different reference sources that are relevant from a health perspective. And with this, I terminate my presentation.
Thank you very much, Francesca and Danie and Ildiko. That was really interesting. If it's okay with everyone, we might go a few minutes over the time. We have a few questions, so if you need to leave, you can just leave, because the webinar will be available to everyone. I think, Danie, the first question is for you. It's from sorry, user error here. Okay, here we go. If I were working on a project that works or takes samples of patients, I'm the only one who had access to the consent forms. The forms are filed and they're locked in my office. If I leave the project, for example, if I resign, what should happen to the consent forms and these records? Thank you.
question. I think it's a very good question. So most countries' laws, not just their data protection laws, require that you have to prove that you've obtained consent. So you can't just destroy the consent forms immediately after you interviewed the person. So if you leave the project and someone is carrying on with that project, maybe they're writing the report or whatever, you need to hand over those consent forms to whoever owns the project after you. So if you've resigned, for example, from the project, whoever takes a lead from that point onwards, you'll have to transfer these consent forms. Depending on whether there is in a specific country where you're doing this assessment a law that says you must have paper-based forms, it might be a good idea to figure out if you can't store these digitally, at least obviously make sure that you use a very safe and secure platform and that you look into all those requirements. That might make it easier, but if someone is going to carry on with this project afterwards, they might need to prove that they had consent to carry out this work. So that would be my suggestion, but it obviously depends on where this project is and what the legal requirements are about these consent forms. There might be specific requirements, so you'll have to check that too.
Thanks, Danie. The next question is also for you, but I think Ildiko can maybe jump in here as well. So if you have a piece of legislation that requires you to collect data and put it in a comment and response report that goes into the public arena, how do you protect the personal information in such case? Because some of the environmental laws are written like that you need to identify yourself and say, I asked this question and I have this comment and so on.
Ildiko, do you want to jump in first?
No, let's cover the legal first, and
okay,
then
cool.
we go into practice.
Yeah. So most countries' data protection laws allow you, or will actually say that if there's a legal obligation on you to process the information, then you must do it. So I always say rather be careful and not put information in something if you don't have to do that. But if there's a law that says this is how the assessment must be done and this is what must be published or filed, then do it. But my advice would always be do as little as you can. So if you can comply with the bare minimum requirements of that law without putting everyone's names or addresses or other details in there, don't do it. But if the law says you must do it, well, then you must do it. But my advice would always be try and find a way not to put unnecessary information in there. And in some countries, you can consult the authorities and explain your situation, and they might understand the situation, and then maybe you can leave the information with the regulator or authority or government office or whatever else, so that there's still a record of this, but that it doesn't end up published somewhere on the internet, for example. It really depends on the specific country. Obviously, if the law says you must do it, well, then you must do it. But I'll try and not do it unless there's a legal requirement.
And then in practice, this often relates to the public hearing for the national EIA, but that's not the only form of public consultation you're going to have. Ideally, you will have a series of meetings on an ESIA that's like a longer conversation. So in terms of like consent, you can obtain consent explicitly stating that this consultation is for the national EIA public hearing, and whatever is recorded here with the name will have to be legally disclosed. But that does not stop people from joining the next meeting that is not a public hearing, just a consultation you organize under your stakeholder engagement plan, and share more details. So this is where the nuances of understanding consent and the purpose limitation of data use will come in handy.
There's a follow-up question for you about that, Ildiko. And it's from someone in the UK because it's a UK email address. Should stakeholders' personal data, e.g. like name, signatures, phone number, be redacted from an ESIA even if they have signed a consent form with a privacy notice?
It really depends on what the privacy notice is. You know, my data protection officer says if her 11-year-old daughter doesn't understand, then it should be improved. So if the privacy notice clearly says that your email, your name, and all this information will be public information, then yes, you can do that. But if there's any doubt or any misunderstanding, then it needs to be clarified at the consent and data collection level.
I also add there, if it's not a legal requirement that those details must go in there, I will definitely redact it. So even if you get consent, there might still be an argument that you've gone further than you should, because under most countries' laws, if you have consent, you must still comply with the requirements, so minimization and purpose limitation. So just because you have consent doesn't mean that you can make that information public. So if you have a legal duty to put it in there, do that. Otherwise, I would still redact it. Just on redaction, a general thing, the Data Protection Commission, the UK ICO, the Information Commission Office in the UK has recently released very interesting guidelines about redaction. So, and I think those are useful guidelines across the world. Go and look at the UK ICO's guidance that came out about a month or two, where practically, if you're sharing documents with any government office, and I think that this is neutral, it's not just for impact assessment, tips on how to redact things properly, because people often make mistakes. I've seen it where you think you've just highlighted something in black and now the information is redacted. It's not so simple anymore these days. There are tools out there that you can use to re-identify. So I can try and find the link and see if I can share it here, but go and look at the UK ICO's guidance, also useful.
I think you guys have really opened a Pandora's box, like Elika said. There's quite a few questions, but I will just want to summarize the last question. And I think this conversation is far from over. It's only the beginning, because I think there's a question about how does data protection work in the context of using AI, which we all use more and more, which is a reality. And then the other thing is that IAIA documents are in the public domain, and we are required to disclose certain things. So that is sort of like we're getting a contradiction here. And also, as social scientists, we gather our information through pictures and words and things like that. And now all of a sudden, a picture speaks 1,000 words, but now I can't use the picture, because even a picture of the iPad will sort of maybe be possible to possible to identify a person. And then also, what do we do with the data once we're done with it? Do you sort of like, because some stuff is not only electronic, some like, do you shred it? Do you burn it? Do you clear your hard drive? What do you do it? So maybe just a conclusionary remark from each of our speakers would be great. And then I don't want to be in Keisha's bad books. So if each speaker can just maybe have a few last thoughts on this. Thank you. We'll start with Ildiko.
Okay, so on AI, there are data protection impact assessments. There are processing agreements that you can check to make sure that your information is not used for model training or even like data analytics. So usually enterprise grade AI tools, such as some of the stuff that we developed, can guarantee you that your data will not be used, but that doesn't apply for free or more generic tools.
Thanks,
From my
Danie.
view,
Last words.
I think it's basics always, whether you're talking impact assessment or the use of AI, go back to the basic principles. I think AI makes things really complicated these days. It's unique, but it's also just another way to process data. So whether you're using AI or whether you're using pen and paper, make sure that you comply with basic principles. And as I said, my golden rule is collect as little as possible, share as little as possible. I want to share a quote, or want to steal a quote from a privacy person that works at Microsoft, and he recently said, when it comes to privacy, it's about how little information you collect. When it comes to AI, it's about how much you collect, because obviously AI models have to train on a lot of data. But with privacy, you have to have as little as much possible when it comes to people's information.
Francesca.
Yeah, on the health aspect, I think also it depends very much on the regulation. There are very clear rules. And on the sharing, for example, the European Union has set up a new rule about data sharing, because we want to make sure that data that are collected in one country can be used for the patient care in other countries. So they are setting up extremely clear rules of what can be shared, how can be shared, where need to be stored, and for how long. And I think also on the issues of how long, it really depends on the national legislation and the group. Occupational health data that can be used in impact assessment have a very specific type of rules that are different necessarily from the data you collect from communities. So if checking the requirement in any setting is fundamental. When we do impact assessment, it's also about which information and who is accessed. Another example on occupational data, if I access information as the practitioner or the doctor, I cannot disclose this information to other people. So it's also who is managing what within the type of data we collect.
Thank you, everyone. This is a minefield because a question just came in, but what about the ESI reports and it's going to make public? How do we safeguard the information? Because we need to use the information as well. So I think this might not be our last talk on this. And as you say, Ildiko, we need to change our way of thinking and our way of doing. But then from our side, thank you very much. I'm going to give back to Keisha to just round it up. But thank you for our esteemed presenters, for your time, for everyone who participated. Sorry we couldn't get to all the questions, but everything will be available. Keisha will tell you more about that. Thank you and good night. Afternoon, morning.
Yes, thank you, everybody. Mostly thank you to our presenters. That was a great conversation. And like we've said, judging by the number of questions that were coming through, very engaging conversation. If we did not get to your questions, I will send those through to the presenters and we'll see if, like Ilse said, maybe we'll have another webinar. It seems like there's plenty that we could talk about in future webinars. I want to mention, as you're leaving today, there will be a survey that pops up for you to fill out. Please do take that time to fill that out. It's very helpful for us to see not only how we did today, but also how we could do in the future. There's this chance for you to suggest future webinar topics, as well as to give feedback on what we've been doing. So please go ahead and fill that out. We really appreciate you taking that time. And if you are an IAIA member, feel free to post something in the hub about today's webinar and keep this conversation going. Or you can also share on social media as well, on LinkedIn, and tag the International Association for Impact Assessment, and we can continue this conversation. So again, thank you to all of our presenters, and a final thank you to all of you participants who joined us today. We really appreciate it. As I mentioned, this webinar is recorded and will be available on the resource library, and the slides are available for handouts as well. I did put one thing in the chat during the Q&A, a link to a document on disclosing documents to the public securely, as well as a link to the podcast that Danie mentioned as well. So those are available in the chat and will be available with this recording on our website. So with that, thank you again, and we hope to see you next time. Have a great day.